Добрый день.
Good afternoon.
Когда мы начинаем нашу сессию,
Could we please start our panel discussion dealing with the subject of state immunity? We have a highly representative panel today, and the issue we are going to discuss is of paramount importance. It's been focused on by the Prime Minister during the plenary session the day before yesterday. The importance of this subject has a lot to do with the concepts of state immunity existing in the modern world. We have to remember the latest judiciary practice. We have to remember the latest subjects raised by the businesses and representatives of the industry. So it was decided to bring the subject up during the forum. This subject is actually quite complex, even in comparison with the subjects discussed by other panels during the forum and even at the plenary session. It is pretty much at the joint of the public law and the private law. On the other hand, this issue, the issue of state immunity, has a great impact with regard to the political situation, to the stability of the investment climate, and whether it's bad or good for us as lawyers. This subject is pretty much the focus of attention for politicians. The subject is rich with political implications. Sometimes it's a facilitation, and sometimes it's an obstacle. In any case, lawyers must produce good results. They must produce good contracts and agreements. I don't think I shall abuse of my today's role of a moderator. Suffice it to say that I can remember my first my first encounter with the state immunity subject. It only happened to me when I was the subject I was supposed to cover at my entrance exam, and it had been in the very end of my pre-reads, and I never got properly read in this subject. I didn't expect it to come up during the examination, not really. But anyway, I had to cover it. Well, or not so well. I did pass the exam, but after I did, I promised to myself that I will sort this subject out. I decided I must know what immunity is and why is it needed for a state. This actually takes care of my rather windy introductory speech, and I would now like to grant the floor to Mr. Peter Pettiborn, counsel to Hogan Lovells, US LLP. I would like to ask him, please, to provide us with an introduction to the issue of state immunity. As a legal advisor, he has spent quite a few years in Russia as head of Hogan Lovells, Russia. He also is a practicing arbitrator. He is practicing arbitration law in Russia and in the United States. I'm sure he can provide us with a broad overview of the issue at hand.
What I'm going to do is set the stage for our discussion of state immunity. And we have here a very distinguished panel of jurists and practitioners and professors who will go into this in depth. So if I could have the first slide. What I'm going to do is essentially definitional, the second slide, by making, first of all, defining what state immunity or sovereign immunity is. It's a procedural bar, it's a defense of sovereign immunity, which arises out of customary public international law that may be raised by states or state entities. Now, there are two levels of state immunity. There is immunity from jurisdiction, and then a totally different concept, immunity from execution. There are two theories within immunity, and one is absolute immunity, and our colleague from China will discuss that because China follows the principle of absolute immunity, but most states follow the doctrine of restrictive immunity. And what that does is it limits immunity to what is necessary to protect the exercise of sovereign prerogatives and powers, de jure imperi activities, and that's not where a state or a state entity enters into legal relationships that could be conducted by private parties, de jure gestionis activities, in other words, commercial type activities. So a state or a state entity that is engaged in commercial activities cannot raise the bar of, or the procedural bar of sovereign immunity. Well, I think there are some things that are more important than sovereign immunity. Sovereign immunity can be waived. And that's very important because when you are involved in a case where sovereign immunity has been raised as a defense, one of the first questions is whether sovereign immunity has been waived. We'll wait for the important announcement to finish. Waiver can take place, for example, in an arbitration agreement, in a financing document. Now, for example, whenever a state issues sovereign debt, it will automatically waive sovereign immunity. It will also, generally speaking, consent to be sued in a particular jurisdiction. And it can even waive sovereign immunity in a specific agreement, waiving sovereign immunity, for example, against a specific asset. See, we have competition. In general, then, it's very often very easy to find the waiver of sovereign immunity as to jurisdiction. As I say, when a state issues general obligation bonds, it will, as a condition of issuing those bonds in the capital markets, waive its sovereign immunity. That's to jurisdiction. The more interesting issue, and we'll get into this in great depth with my fellow panelists, is execution against assets belonging to a state or a state entity. Generally speaking, three principles. You need to show that the arbitral award or the judgment relates to de jure gestionis activities. Second, that the assets are not dedicated to sovereign tasks. For example, you can't ever execute against an embassy. Or that there's an express waiver with respect to those assets. And thirdly, that there is a connection between the underlying transaction to which the award or the judgment relates and the enforcing jurisdiction. Now we get to the interesting part, which is that even where these factors are satisfied, it is often very difficult, if not almost impossible, to enforce an award or a judgment against assets belonging to a state or a state entity if the state or that entity wishes to contest the enforcement. So it raises the wonderful paradox. You've got this judgment, terrific, and now you seek to enforce it against an asset, and you find that you cannot do that. I cite two examples. One is the Noga cases, which involved attempts over a 20-year period to execute against assets belonging to the Russian Federation and entities of the Russian Federation, including artworks, including MiG aircraft that were at an air show in Paris. There's a fascinating account of the Noga saga written by Dominique Berset in the 2011 Austrian Yearbook on International Arbitration. It makes for very interesting reading because, among other things, she describes art moving across Switzerland, seeking to make its way back to the Russian Federation. And hour by hour, various actions were taken in various courts, and then actions to seize were set aside, and then they were reinstated, then they were set aside. It's almost like a detective novel. And then very contemporaneously, you probably read about the arrest of the Argentinian tall ship Libertad in Ghana, Africa, and then its subsequent release by the Law of Sea Tribunal sitting in Hamburg. One might say, what's a Law of the Sea Tribunal in Hamburg have to do with the seizure of a vessel in Africa? But it just shows the worldwide application of these very interesting issues. So with that, I will conclude and turn it over to our wonderful panel to have them explain in great detail how execution can take place. Thank you.
Да, спасибо большое. Если вдруг будет...
Thank you so much. If we do eventually get any questions, make sure you raise your hand. And after each presentation, after the contribution of each speaker, we shall try to take advantage of the time available and give everybody a chance to make comments or ask questions. If we don't have any further comments or questions, we might just as well proceed to the other speakers representing the principal actors of the state immunity-related procedures. I'm talking about the judiciary. It's the judiciary that largely affect the implementation and enforcement of the state immunity mechanisms. With this, I am happy to grant the floor to Mr. Clifford Wallace, Senior Judge of the U.S. Court of Appeals for the Ninth Circuit. I believe that he's going to discuss the subject, which is very topical for the Russian Federation. It's the impact of the immunity-related issues with regard to the principle of separation of authority and separation of power. So could you please speak about all these discriminations, the forms of participation in proceeding of executive bodies?
Enough, I have friends here that I made in San Diego. You would think, 50 years ago you wouldn't have friends halfway around the world, but due to the open world policy, we've had visitors of the judicial area come, and I've run into some of them here. And it indicates that the world is getting to be a smaller village. And that's why we're here today. It wasn't like this when we stayed in our own ground. But now with transportation, with business and industry the way it is, we've brought upon ourselves certain complexities. And now we have to deal with those. And that's what I want to talk about today. Yeah, I noticed in the outline of the program that it indicated about the courts and separation of powers, because we have to make a decision. Who makes the decision? Who decides whether or not immunity is going to be granted? And I happen to believe it should be in the courts, and I'm going to spend a little bit of time on that. Yesterday, I had a chance to talk about several doctrines which the United States courts exercise jurisdiction over foreign entities, and talked about several of our statutes that deal with this. And of course, one of the cases that is of concern today in Russia about the Jewish papers. And I compared that case with a case I wrote for the Ninth Circuit, a different circuit that the Jewish papers came out in, indicating a little different approach and perhaps more restrictive approach on how far we can reach a country in a situation such as that. I won't, I know all of you were there, so I won't repeat myself. But I do want to discuss briefly with you the role of courts in determining immunity decisions. And I want to expand upon that. One of the biggest threats to foreign investment is risk. We're talking here about business and industry. How does it fit into all of this? We're talking about businessmen who must make choices, investments. We're talking about government agencies who are doing the same thing. And I don't think it's a controversial statement to say that risk scares off potential investors and hurts business. It's just a problem if you have the cash, you don't put it where it's at risk, you put it where it is secure. And we can see that every day in the petroleum markets. Each new risk drives up the price of a barrel of oil. Now, one area that need not cause undue risk for investments and businessmen in general is the area of foreign sovereign immunity. That is, how and whether a state or state instrumentality will enjoy immunity from a suit in another country's courts. That's the issue we have. And while this issue is far from settled, and multiple approaches exist, and you'll hear about them today, my belief is that a deeper recognition of the importance of a system of separated powers can aid in clarifying standards that may apply when a state immunity question arises. A system of separated powers, though tricky in the area of foreign relations, can provide predictable rules for businesses so they can make better choices with their investments. Predictability fosters stability. Stability fosters investment and long-term growth, and that fosters an increased standard of living among our people. So what we're talking about today is not a lot of large businesses and a lot of large governments. We're talking about the best way for the world to enjoy the benefits that come from industrialization and the modern market economy. And that, to me, is a critical part of what we do. I have devoted much of my work around the world the last 40, 50 years in preaching the importance of separated powers, including an independent judiciary. As judiciaries are independent, they are free from the whims of the executive and the legislative branches. The rule of law thrives and flourishes when there is judicial independence. It's at risk otherwise. The importance of separation of powers translates to the foreign affairs context. Indeed, in the context of foreign affairs generally and foreign immunity specifically, the branches of government each have a role to play. The legislative branch, for one, plays a different role from the executive. The executive is involved in the actual carrying out of foreign policy. But the legislative branch, on the other hand, plays this other significant role. And in my country, for example, the Congress enacts legislation and appropriates money. Unless it appropriates money for foreign affairs, there's no foreign affairs. Without any appropriation, the power of the executive would be completely frustrated. Further, the Senate advises and consents to appointments of the executive branch. Likewise, the Senate must embrace all treaties. Once a treaty is approved by the Senate, it becomes the law of the land, which all courts are bound to enforce. The judiciary has a much different role in foreign affairs. The judiciary lacks the institutional capacity to make foreign policy decisions. Instead, the judiciary's chief role in foreign affairs is to do what it always does: ensure due process of law. This does not mean that the judiciary has no responsibility in the foreign affairs area. Significantly is, at least in the United States, emphatically the province of the duty of the judicial department to say what the law is. That is, once the law has been adopted, we define what it means. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws come into conflict with each other, it's the courts that decide upon which is the operation, which is to be operative. Thus, to some extent, because the judiciary must interpret the meaning of the law, the judges must interpret the laws bearing on foreign affairs. And indeed, the Supreme Court of the United States, once the executive and the legislative branches have performed their role, interprets and applies the treaties and the statutes touching on all foreign affairs. Now, why is this important? Because it isn't involved in politics. As long as the executive and the legislature are going to make those decisions, it's going to be political. But we have the opportunity to have a separate legislative body which is divorced from and not under the direction of the executive. And I'm suggesting that in all these roles, all of these areas where we're dealing with this particular subject we have before us, that the decision should be made by a separate independent judicial body as to what the statute means. Now, for example, prior to enactment of the Foreign Services Immunity Act, the State Department of the United States used to decide on whether there's going to be immunity or not. The State Department, the Department of State, is an executive branch. Who tells the state what to do? The President of the United States. So the President was actually making the decision as to whether or not there'd be immunity. The President, through the State Department, has political issues. Those don't deal with businessmen. Businessmen want to know, what are the rules so I can make a decision on whether to invest? I want protection. I want the ability to go into court. I don't want to have this done through the back doors of politics. I want to go into court and present my view, and I want to have a judge tell me why I'm right or why I'm wrong, and I want an opinion that I can then take to a higher court. Which is better for making the decision? I suggest to you that you may lose in the court, but it's far better to have your case that you present open and transparent with an opinion made that you can then take to a higher court, and still the highest court if it can be taken there. And that's why there's a great movement now to have an independent judiciary make those very important decisions. Now, international bodies have also recognized the importance of insulating immunity decisions from the political expediencies. For example, in 2004, the United Nations General Assembly adopted the UN Convention on Judicial Immunities of States and Their Property, which adopts the restrictive theory of state immunity, which was referred to before. That convention has not yet received the adequate number of votes to ratify, but it's moving in the right direction. Of interest to this discussion, both Foreign Sovereign Immunity Act and the UN Convention state as a general proposition that a state is immune for its public acts. Both also contain exceptions, however, for commercial activity where the state has waived immunity. So the restrictive area is that there is immunity and that we don't have the opportunity of having somebody else tell us that we're not immune. And it's in an area under the restrictive area given to the courts where you can have your day. Now, I don't advocate anything further than that. I'm a firm believer in the judiciary, in the independence of the judiciary, in the separation of powers. It's been my life's work. So I'm prejudiced. I understand that. But I think that the position that I have suggested today is far better for business. Why? Because if it's in the courts, it's predictable. It brings stability. There's less risk. Therefore, it'll encourage more investment. It'll encourage a higher standard of living for people and grant the goods of a free market to a larger group throughout the world. What's wrong with that? I think it's a good idea. Thanks for listening.
Да, спасибо.
Thank you very much. I think that, like Mr. Wallace said, we have exactly the same situation when legislative power should, by adopting a right law, should provide transparency and transparent rules, and the courts, when passing their judgments, would not be dependent on any political will. I think we'll go further. I mean, from the West, we'll move across the Atlantic Ocean. We move to a different jurisdiction, which is also very well developed in applying the immunity mechanism, the state immunity mechanism. And I would ask to ask Sir Nicholas Hamblen, Justice of the High Court of Justice of England and Wales.
Good afternoon, ladies and gentlemen. My name is Nicholas Hamblen. I'm an English High Court judge, sitting mainly in the Commercial Court, which deals with a lot of international disputes. The topic of my talk today is going to be the actor-state doctrine in the modern world. Now, the actor-state doctrine is the first cousin of the doctrine of sovereign immunity, and the doctrine and its developments illustrates well the fundamental question: when and in what circumstances should the court adjudicate over sovereign matters? So, what is the actor-state doctrine? It's a common law doctrine, and in particular it's an Anglo-American law doctrine, and it reflects the principle that a court will not adjudicate upon the act of a sovereign government acting within its own territory. And a classic statement of the doctrine which has been often applied both in England and the United States, is a decision of Chief Justice Fuller in a Supreme Court decision as long ago as 1897, when he said this: "Every sovereign state is bound to respect the independence of every other sovereign state, and the courts of one country will not sit in judgment on the acts of the government of another done within its own territory. Redress of grievances by reason of such acts must be obtained through the means open to be availed of by sovereign powers as between themselves." And a good illustration of the application of the doctrine in the English courts was a series of decisions which followed the Bolshevik Revolution in 1917 here, in which claimants were making claims to property which had been nationalized by the new government. And the English court's position consistently was that this was a sovereign act by a recognized friendly government, and it would not even inquire into the question of the legality or validity of those acts of expropriation. The doctrine is allied to that of sovereign immunity. The difference is that it's based on the subject matter of the action. It's not a personal immunity, nor is it an immunity that attaches to property. As with sovereign immunity, its rationale lies in considerations of comity. The principle being that a sovereign state should treat another sovereign state as it would wish to be treated itself. Because the immunity is based on subject matter, its application in many cases will raise issues of separation of powers, because very often the question is this an act of state or not, which itself raises the question, well, what is an act of state? Now, the doctrine is easy to state in general principle, but its boundaries are far from clear. And there are 5 boundary issues I would like to touch on briefly today. 1, what are the acts of state which are covered? 2, what are the territorial limits of the doctrine? 3, what type of challenge to an act engages the doctrine? 4, are there exceptions to the doctrine? 5, does the doctrine apply to commercial acts? And there's been a recent important English Court of Appeal decision in a case called Yukos and Rosneft, which addresses all these issues, and the Court of Appeal analysed the doctrine in some detail as well as restating it. So I start with question 1, what acts are covered by the doctrine? Does it cover administrative acts or judicial acts? The classic application of the doctrine is to purely executive acts such as legislation or decrees. But clearly there are other governmental acts where the boundary is less clear. Now, in the Yukos case, the Court of Appeal decided in terms that the doctrine does not and cannot apply to judicial acts. And that was so even though what was being alleged in that case was that the judicial decision had been procured by the executive and therefore to that extent could be regarded as an executive act. The court said no, the judicial acts fall into a different category consistent with the separation of powers and cannot be the subject of the act of state doctrine. But they went further than that, and they also said that quasi-judicial decisions such as tribunal decisions, which in that case was a tax tribunal, are also not covered by act of state doctrine, and that is because they are essentially decisions guided by legal norms rather than political processes. And the court said this, that unlike legislation or decrees or the acts of commanders in the field, which are the familiar terrain of the act of state jurisprudence, such assessments function within a code which is designed to operate according to law and to be subject to legal and indeed judicial rulings. And in reaching this decision, the court said in terms it was paying deference to the rule of law. And it put it this way, there's barely a country in the world which does not subscribe to the doctrine that justice according to the law is what is expected of its courts and judges, or does not subscribe to what is more and more being expressed as a global deference to the rule of law. So here is a concrete example of the rule of law in action, as well as the doctrine of separation of powers. Question 2, the territorial limits of the doctrine. The territorial limits are to the boundaries of the state itself and to acts within that state. Exceptionally, there may be cases where analogous principles apply outside a territory. An example in the English jurisprudence is a case of Boots, Gas and Hammer, which was a defamation and conspiracy case, which raised issues about the rights, competing rights of two sovereign states to parts of the continental shelf. And the English court said these are not issues which a domestic court can adjudicate upon. They have no reference point. It's a judicial no man's land. And they refused to enter into the question. Question 3, the type of challenge required. Another point emphasized in the UCOS case was that it's not every consideration of an act of state that excludes the court from deliberating. There may be many circumstances in which the background to an act being taken and the reason it was the court, in order to reach its decision, to make a decision upon the legal effectiveness or validity of the act itself. So it's positively engaging or having to engage in the question of legal effectiveness. And it was put this way in another Supreme Court decision called Kirkpatrick in 1990. The courts have the power and ordinarily the obligation to decide cases and controversies properly presented to them. The Act of State doctrine does not establish an exception for cases and controversies that may embarrass foreign governments, but merely requires that in the process of deciding, the acts of foreign sovereigns taken within their own jurisdiction shall be deemed valid. Question 4, are there exceptions to the doctrine? There are some specific exceptions, but one general exception recognized in the English case law is a public policy exception, that the doctrine exceptionally will not apply to foreign acts of state which involve a fundamental breach of established rules of international law or where there is a grave infringement of human rights. Now, potentially that could be quite broad, but in fact there's only been one case example of that exception being applied, and that was a case which followed the Iraq invasion of Kuwait, when the Iraqi state, purporting to exercise powers as sovereign of Kuwait, expropriated the Kuwaiti Airways air fleet. And perhaps not surprisingly, the English court refused to recognize that as an act of state. And in reaching that decision, it emphasized the increasing importance of international law and of the interdependence of states within international relations. And it commented as follows: the acceptability of a provision of foreign law must be judged by contemporary standards. The courts of this country should give effect to clearly established rules of international law. This is increasingly true today. As nations become ever more interdependent, the need to recognize and adhere to standards of conduct set by international law becomes ever more important. And fifthly, I come to an area of overlap with that of state immunity, which is whether the doctrine applies to commercial acts. And the answer is no, it does not, for similar reasons that in general the state immunity doctrine does not apply to commercial acts. And regardless of political embarrassment that may be caused by investigating issues concerning commercial acts, the courts will engage with them. And as the court emphasized in the UCOS case, caution needs to be maintained when considering how far broad statements of principle made in another era, when the doctrine of absolute sovereign immunity held sway, still apply or extend in the modern world, in which it's now accepted as a matter of general international law that there is no immunity for the state's commercial activities. So I come to my conclusion, and essentially 3 points. Firstly, the decision in the UKOS case helps to illustrate the boundaries of the doctrine and shows that the doctrine, as was put by the court, is being defined like a silhouette by its limitations. In other words, the exceptions are increasingly taking the place of the rule. Secondly, as with the related doctrine of sovereign immunity, the absolute no longer holds sway. English law is moving away from the idea that the act of a foreign state will be regarded as untouchable. Instead, a more restrictive doctrine is emerging. And that recognizes that there are rules which are fundamental and universal, such as modern international human rights law and the rule of law itself. And thirdly, the increasingly restrictive approach to the act of state doctrine reflects globalization and the increasing independence of states. In such a world, a state's acts will often have external effects and find itself made subject to international norms. Thank you.
Да, спасибо большое за такое
Thank you.
иммунитета.
Thank you very much for this most comprehensive presentation of the state immunity concept in the British law. As we are saying in this country, some Russian-based cases are going away to the British courts, but in fact we are now aware that the English system, the British system, is now becoming more and more focused on self-awareness with regard to these cases. If there are any questions to Justice Hamblin, we can take these questions. If not, we can proceed with our agenda, and let's move on eastwards. Here we are on Russian turf. I would now like to grant the floor to Madam Kudelich, Dr. Kudelich, Deputy Head of International Law and Cooperation of the Supreme Commercial Court of the Russian Federation. She has spent a long time working with the concept of state immunity, and I would like her to now take the floor, please, and follow the discussion in the context of the international approach. Thank you. As I was preparing for this presentation, I wanted to make it as dynamic as possible. So quite a few of my statements shall be worded so that they generate some criticism from you, from the audience, and that's exactly my purpose. I wanted to abandon any dusty academic approach. I wanted to talk about the immunity of foreign states. That is very much a focus of legal activity in Russia. The issue of foreign sovereign immunity has been discussed for a few years by now. Last year, during the second International Legal Forum, we did hold a very similar panel discussion dealing with a similar subject. And the overall question was, is immunity in line with democracy, or is it not? And why do sovereign entities have to have immunity in the context of their commercial activities? To be fair, I have to say that the panel last year was sponsored by the American Bar Association, so it was a little bit Americanized. But nevertheless, it was pretty comprehensive and gave us a lot of insights into the subject. It was most interesting to understand, to learn that the foreign sovereign immunity in Russia got out of the shadow and obliqueness and became topical and generating a lot of interest. We have to remember the first draft law on foreign state immunity. The law had its first hearing back in 1995, and then it got forgotten all the time through year 2011. Now we're trying to understand why was the law not enacted? Were there any political reasons for that? Was there any political counteraction? But the answer was and is pretty simple. Everybody forgot about that draft law because nobody seemed to need this law enacted. Nobody needed it, nobody spoke in favor of it, so it was dismissed. The draft law and its consideration was dismissed totally. And it stayed buried all the way through year 2011. It would have probably remained where it was, but then the situation changed thanks to our British, not American, but British colleagues. They gave us quite a kick, so to speak. In this distinguished audience, I could have used a stronger word, but anyway, they really told us what they thought about the reality in this country. That was quite a revelation for me. Dr. Galperin shared his memories of his students' years. I can share some experience of my teaching years. Back when I lectured to officials from the Ministry of Foreign Affairs, they told me, my listeners told me, that it's the functional and not the absolute immunity that is the buzzword of today. They told me that we were too liberal, and all those schemes and concepts were rather alien to the modern reality. And I started thinking that some people have very wrong ideas of foreign sovereign immunity, especially. And I would now like to refer to the speech by Prime Minister Medvedev. We have to understand the specific nature of this institution. It's very much at the interface of national and international, domestic and global. And of course, this is an institute of international law. And last year, you remember that case, Germany versus Italy, and the case dealt with the norms of international law. It's the norms of international behavior, and it's not that a state can use or neglect such norms. That was an important statement. But in spite of the international nature of the case, a state always decides to use the concept of foreign state immunity at its own discretion. Of course, there is the UN Convention, and we can do the comparative legal analysis. We can always say that different states have very diverse views with regard to foreign sovereign immunity. And all this helped me to understand why Russia stuck to the absolute state immunity concept for such a long time. It's all because of us attaching some sacred meaning to the concept of a state. A government in this country, is like an Indian holy cow. It's untouchable. And when a state registers the standard of absolute state immunity in its law, the state does not really try to gain a benefit for its own self, but it thus punishes private individuals and legal entities. The state prevents them from protecting their own rights, which is not the case in the Western world. We have to remember the resolution in the Oleinikov versus Russia case. Remember the European Court of Human Rights. Even the European Court has reprimanded us that the concept of absolute state immunity is obsolete. It's in violation of Article 6, and we have to remember that Article 401 of the Civil Procedure Code. This standard is already a legal stipulation, a legal provision. These days, we are trying to exercise a rational and balanced approach to finding the methods for procedural response to competitive jurisdictions. There is indeed a competition, and the state, the government, must respond to competitive challenges. The foreign state immunity is a very good way to respond. That's why we got actively involved in drafting a new law on foreign state immunity. The work is at its inception stage. The draft law exists, though. We have circulated it to the different ministries and agencies. We believe that the overall concept stays intact. We have tried to formulate it so that the concept remains, the basic principles stay. But what makes the law, the draft law, different from the convention is that we try to emphasize the procedural block, the way the court procedures related to cases involving foreign sovereigns. The role of the Ministry of Foreign Affairs is clearly stipulated, and that role is quite substantial. I'm now abusing some of my powers indeed, some of my authority, and I would like to make a bridge, to construct a bridge leading to the presentation of my colleague, Dr. Dronov, representing here the Ministry of Foreign Affairs. So the Ministry of Foreign Affairs is going to play a very active role in further promoting, in further developing this draft law. And the Foreign Affairs Ministry will actually have to select between the two options of status. They will probably give an opinion with regard to the independence of the sovereign and who can represent a state and in which status, and who will do the notification of the foreign states. I believe all that is clearly stipulated in the law, in the eventual law. Also, there is quite some ground for discussion with regard to whether or not we can see the limits, whether there are limits of the state participation, of the Ministry of Foreign Affairs participation with regard to cases involving foreign state sovereignty. We now know that the Department of State of the United States is an active intruder into such cases. They provide weighty opinions. They interfere actively into whether or not a foreign state shall be granted immunity or not. In Russia, in the Russian law, we shall be based upon the idea of reciprocity. We shall just assess whether or not a foreign counterparty grants us state immunity or not. We can be guided by the International Court of the United Nations. Whether or not we shall see whether or not we can use reciprocity as a principle, whether we can involve the Ministry of Foreign Affairs at all, whether we, when I say we, I mean the court, a court, whether we can accept the expert opinion of the Minister of Foreign Affairs with this regard. I believe all these questions are extremely topical and significant. They invite some broad discussion. Now, another point with regard to immunity. The case of Schneerson Library. From this case, we know that the issue of state immunity is very sensitive at the state level. It's sometimes pretty difficult to discriminate between the commercial and non-commercial components of the case. Well, In this particular case, the jurisdiction of the American court was based upon entirely different circumstances. Again, this is a sensitive issue for any state. A state is never happy having its own affairs considered within a court case, a court litigation in a foreign state. This immediately becomes a precedent and becomes part of history, becomes part of case law. Such cases are never overlooked and underestimated. They always have an impact upon further development of law and legal environment. I would now like to raise another point, and I'm sure it will be echoed by some of my colleagues. Last year it was discussed too. The issue is state participation in investment arbitration. I'll only raise two statements. On the one part, the state should conclude a bilateral agreement on protection of foreign investment. The state actually agrees to protecting foreign investment.
And they should have those closures, understanding that they can be filed a suit. But the number of those arbitration cases and our participation in this process is not yet that big. If we look at the history, the story with Argentina, which really suffered from it, all these stories, I mean, you are familiar. However, this problem of the investment arbitration immunity touches on the very urgent issue. What is the link between the judicial immunity and the executive immunity? Even if the state refuses or a foreign court decides that the state is not using the judicial immunity, waives the judicial immunity, but the immunity from compulsory enforcement still remains. There are many complex questions. For example, Zadelmayer versus Russian Federation, when their trade representative was arrested, and there are many complications. And for our law, it's a very we have to understand how do we link these two immunities together, whether they should depend on one another, interdependent. Do we follow the global trend, or do we listen to the International Court in the UN, which says no, these two immunities act in separate ways? It's a very complex question for us. And again, to conclude, I would like to pass the idea to the next speaker, Alexei Dronov, and maybe try to discuss this issue. How does the state, and it's a very complex question, how does the state that suffered, so to say, what can this state do to compensate, to put it softly, to compensate for the negative decisions, for the negative judgments? All these discussions, they happen at the political level, and everybody becomes aggressive. But if we get to the legal field, what can we do using international public law? How can we solve it in an elegant and efficient way? Maybe we ask our colleague from the Ministry of Foreign Affairs to explain. Thank you. Thank you for this emotional presentation and showing that you really know what we're talking about here. And I think you showed us the trends we have in Russia now in regards of how many problems we have to solve, how many challenges we have to face, and how different our experience is from the international one. But before I pass the word to Mr. Dronov, because I have no way out. I mean, he's the next speaker. I guess he represents the body which which is the first to learn about these cases. And I would suggest some comments. Peter, please.
Quick comment that ties together both Judge Wallace's comments and your comments, which is a recent case arising out of the Argentinian defaults. There was no question but that Argentina had consented to a waiver of jurisdiction. And there was no question but that there were judgments against Argentina. Now, the plaintiffs sought to attach assets of the Central Bank of Argentina in the Federal Reserve Bank in New York. And interestingly, opposing the attachment was the Department of the Treasury and the Department of State. Nevertheless, the Second Circuit held that under the Foreign Sovereign Immunities Act, these assets were immune from execution. So it's an interesting thing because both of our departments, governmental departments, said these are immune. Nevertheless, the court determined that, yes, that they were immune, and they were doing it simply to encourage foreign governments to deposit their dollar assets in the Federal Reserve Bank. And yet the court made its own decision under the Foreign Sovereign Immunities Act.
Есть еще какие-то вот комментарии или вопросы?
If there are any more comments, if none, then we ask Mr. Dronov, Deputy Director of the Legal Department of the Ministry of Foreign Affairs, and he will probably tell us what our Ministry of Foreign Affairs thinks about the subject. Thank you, Mr. Moderator. First of all, I would like to thank for the invitation to come to this forum, and I'm very pleased to be in the audience where I have so many people who now understand what we're talking about and are interested in the subject. And I would disagree with my colleague. We always paid attention, and the international community always paid, and the Russian Federation has always paid attention to this immunity matter. And I can tell you a few words about the law we used to have and the law we're still going to have, which is being passed. But I would like to point out two aspects. As an introduction, it will be a lengthy speech, but I'll try to stick to the topic. We have a lot of non-interactive speeches. We don't answer the questions that are given as the starting point of discussion. I'll try to answer the question. I paid attention to the fact that all my facts are talking about judicial practice. In contrast to this, I would like to say that Russia views, and I have an authority to state it. It won't be an official statement, but it will be something in between my personal idea as of a lawyer, but also representing the views of the Ministry of Foreign Affairs. In the Constitution, we have Article 4, which provides for the international legal norms to be part of our legal system. I remember when my mentors said that this norm, this principle, was utopian for Russian legislation. But now we understand that this principle is very functional. But it creates challenges for legal system in the sense of executive powers. I mean, in regards to executive powers and judicial powers. And I cannot agree to my colleagues who tend to emphasize the judicial system. The principle of separation of powers is a fundamental part of the constitutional mechanism. But we're talking about norms of international law. We're saying that executive power has prerogatives in foreign affairs, and we say that the judicial powers acts if they are not legal, I mean, who is to answer for these acts? It is the state that is responsible for these acts internationally. So in our understanding, the concept is to understand the necessity of interaction between different branches of power, including legislation, on the principle of compliance to the norms of international law. Why would international law be a key term in this context? For a very simple reason. We live in a global world. We live in a situation when transaction and become very complex, judging from the jurisdiction. We live in a situation when we have to define very clearly the jurisdiction, but we don't have a unified norm. We don't have written norms that would be ratified, that would be acknowledged, adopted by all states as a universal document. And the courts are responsible for applying recognized norms of international law. And one of these principles is a principle of sovereign equality of the states. And this principle is an imperative norm of the international law. But we have another myth on the way, and I would underline that it's a myth. The principle of sovereign equality, which is an imperative norm, often leads to the principle of imperativeness of the immunity. And this concept has no grounds at all. Even this theory of absolute immunity, as my colleague said, this theory means waiver of immunity. Even this concept does not mean that this principle is imperative. It's an imperative. In the theory of limited immunity, we have to deal with a completely different situation, because those parties that participate in establishing their legal relations, and they are based on an autonomy of will, we see a situation when these parties can assess, evaluate international legal context in which they act, and make a decision whether it's reasonable to enter legal relationship with this or that state or with this or that party. And if they enter this relationship, they need to try to lower the risks, the commercial risks that can be imposed by this immunity principle. So, speaking of the principles of the sovereignty, which is stipulated in the UN Charter, we need to make a division, to differentiate between the immunity and the consequences that it may lead to. And it has been underlined in the Russian doctrine as well. There's a work by Irina Khlistova, which gives a very interesting conclusion about the dispositive character of this doctrine. If we're talking about international practice, I should mention the decision of the International Court of Justice. This court is one of the major bodies of the UN, and it has lately tried a case between Germany and Italy, when we speak about the decision, we should take into consideration the immunity issue, because the decision gives a number of elements, a number of hints of how we should interpret the principle of immunity. Well, the International Court said that breaching the immunity principle, especially when resolving dispute in courts, in certain courts, infringes with the principle of immunity of sovereign immunity, and according to the norms of international law, leads to international liability of the states. And here I react to what to the question of posed by Mrs. Kudelic of what should be done. And I would like to emphasize that the ground for this liability is a decision which is already enforced, and regardless of the fact whether the measures for compulsory enforcement are being taken. Since we've been talking about Schneerson case, and it was said that it was kind of a kick, I find it difficult to see who kicked whom. It's difficult to say, but I can say that the American judge passed a decision which violates the norm of international law, and it's judicially void. Hence the question whether such decisions comply to the rule of law, to the principle of the rule of law. If a sovereign state goes to court and claims their immunity, and the norms are not applied, the norms of law are not applied, it's a non-legal approach. So this case is still pending. If we're talking about the practical side, we understand that this decision cannot be compulsory enforced, but there are questions about the very existence of this decision in the context of international liability. And I would also like to emphasize that the refusal of the state or a court to take measures to obstruct those invalid measures serve as a basis to take measures against this state. And that may include limitations to refer to their immunity in courts, arrests, and property extraction. It is part of the international life. It is part of the sanctions. The idea that international law is vague, that there is no sovereign, I think it's also a myth. Because if we're using the categories of international law and categories of liability and a threat to take measures, the sanctions can be very efficient in international law, regardless of the size of the state. Nobody is interested in creating tensions and conflicts in the relationships between countries. And I think it's crucial for our discussion when we use the term competition of jurisdictions. I would like to say that we have the UN Charter, the principles that serve as basis for the life of society in today's world. And if we don't take these principles into consideration in various contexts, we won't go far. It's impossible not to take them into consideration. And the fact that international law protects sustainability of the international relations based on trust, based on mutual interest and mutual interaction and cooperation, it is something we have to take in mind when we speak about immunity. Why would it be so important now? I won't tell you anything that you don't know. You have it in the doctrine, and my colleagues keep talking about it. The state does not only limit, it widens, it broadens the specter of its participation in the economical life. And it often acts as a subject of legal relationship, and in the situation of globalization, these acts are often not only transnational but global, and it falls under several jurisdictions which are part of various legal systems, and providing this compliance, I think it was. We had a discussion in the Hague in April 2013 during a celebration of 120 years of the Hague Private Law Convention, and there was statements made many times, and all the speakers representing UN bodies, they kept speaking about the growth of the importance that international law has in financial and economic relations.
So we have to go on with the codification, and this shall complement our efforts of interpretation of the international laws. When the state is a subject of such legal relations, importantly, it does not lose its quality of sovereignty. It does not become a private entity, a private person. It's in fact a sovereign that voluntarily agrees to get involved in the relations regulated by the civil law standards, alongside with other participants of the turnover. This is the very idea of law and justice. A state, a government, is interested in maintaining the intact system of law, the intact legal system. They often say that it's only in public relations that the state is the carrier of public authority or public power. I do not agree. If it were so, there would be quite a number of purely practical problems. Unexplainable problems, too, like how can we explain the need to regulate the participation of a state in such relations, and so on. So there is a certain dualism of the legal nature of a state, and it clearly stands out in its economic activities. So we have to understand why and when a state, a sovereign state, becomes subordinated to a foreign jurisdiction. Is this a weakness, or is this an ailment when a state has to go under a foreign jurisdiction? It is neither. It's a normal manifestation of international life. One state, as a sovereign, agrees that a certain relation it's involved in shall be regulated by a jurisdiction set up by another state. This is a value that needs our protection, and we can protect it by securing fair and just law enforcement. So getting back to our principal issue, I can say that state immunity, in fact, performs a unique and stimulating regulatory function. On the one hand, it secures respect and compliance with the state of a foreign government as an entity in its full right. Its full rights of sovereignty. That's why immunity, state immunity, is one of the guarantees of friendly cooperation between jurisdictions, as opposed to collisions and competition. On the one hand, state immunity secures for a state a possibility to take part in civil relations. And under market economy conditions, this is within the best interest of the state and the economic turnover stakeholders, because a state, a government, is an extremely interesting business partner. That emphasizes the value of such relations. So it's basically about the balance of legitimate interests of all the stakeholders of economic life, including a sovereign state. And this brings us to the very essence of the issue under discussion. How, under current conditions, we can secure this kind of balance? Very often, when international legal practitioners ask themselves this question, they try to compete with one another in giving the best answer. Well, in this situation, I have a very comfortable feeling. I do feel comfortable because we do have an answer to this question. International law and international legal practice and the doctrines, as we know from the decisions by international court, grant us a very definite answer to the question. The balance is achievable when based upon implementation of different legal regimes applied to the activities of different states. Those states are function within their sovereign functions, the act of jure imperial, and non-sovereign types of activities, which are commercial and trade activities. This is neither a new nor an original discrimination, but it's fundamental to understand the function of immunity. In fact, this discrimination, this separation, is the very essence of restricted immunity, if we look into the very essence of the matter. This makes it principally different from the concept of absolute immunity, which used to dominate until very recently. We don't have to consider Russia as an exclusion here. Russia is not. I don't think this country has yet abandoned this area of argument, but the argument is not as heated as it used to be. The argument between the advocates of the absolute immunity versus the restricted immunity. But I would like to invite all of you, dear colleagues, to be very cautious about criticizing the concept of absolute immunity. Following this concept of separation, we have to deal with the area of law, which is much broader than economic activities. For example, the legal relations involve some diplomatic functions or military activities. Activities related to spacecraft. I'm just giving a few examples of activities which fall under the absolute immunity principle so far. So I don't think we have to say that only functional immunity exists, and that's it. I invite you to be very cautious in your definitions and assessments. I would now like to take advantage of this unique opportunity to pay your special attention to the fact that the international community has completed a huge and most significant effort, which is the codification of state property. This project was based upon a body of articles, commented articles, prepared by a body under the United Nations. The body is the International Law Commission, and the effort was completed back in 1991. The Commission most scrupulously analyzed the issue, but that was not all. The problem is of such paramount importance to all the states that after the consideration by the Commission, there were several meetings of the working group and the steering committee set up under the General Assembly of the United Nations. And it was only back in 2004, after all those complicated efforts, we could see that within the national jurisdictions, the states sometimes took different ways to proceed. And that was the climax of international cooperation. There was a lot of exhilaration over this compromise it was a unique case. It was a unique situation in the life of United Nations. The text was in fact a codification and a huge progress of international law. So the text of the revision of 2004 was adopted, and Russia was among the countries that did not only welcome the convention but also signed it. That happened back in 2006. The convention is not in force yet. It can only come into force after the 30th ratification charter is deposited, which is a standard procedure for the United Nations. So far, we've only got about half of those documents deposited. 31 countries, 31 states have signed, though. This is an extremely serious document that has a huge impact upon the legal practices of various states. How can that be? The text of the document has been adopted by the United Nations General Assembly. The UN resolution does not only appeal to the state to join the convention, but in fact, it stimulates the countries, it encourages the countries to adopt acts of law identifying their state immunity approaches. We often refer to that convention, especially when we have to talk to our judicial colleagues as they approach us with their requests. So this document for us is largely a codification of international law norms, and those are in force whether or not the convention is ratified. This instrument is unique and important, very much so because it has a very balanced approach to immunity-related issues, including the definition of a commercial transaction, as mentioned by my colleagues. My colleagues have already mentioned the concept of a commercial transaction. There's been a long discussion centered around this very concept, and the outcome was very elegant, in fact. It was a combination of the criteria of the nature of a transaction and the criteria of the purpose of a transaction. In other words, a contract shall be concluded as a civil law agreement, and that shall be proved by the fact that a state, as part of an economic turnover, can be subordinated by a foreign jurisdiction, but that shall be modified with regard to the purposes of using the tools of international private law, because the purposes can be different. It can be generating a profit or generating an income, or setting up an enterprise, or it can be provision of humanitarian aid, or say supplying helicopters for a UN special mission, or something else to that matter. So the purpose criteria, we managed to get the purpose criterion included. It's very important to mention Section 4 of the Convention. That's about enforcement measures. Why is it so important? Primarily because it is a very good reflection of the concept of judicial immunity and enforcement immunity before and after the court award. And a waiver of one kind of immunity does not automatically mean recurring to the second kind of immunity, and is guaranteed. That's why the immunity norms are so valuable and valid. This balanced approach is also proven by the fact that the Convention does not touch upon the interest of the states that are regulated by special norms of international law. Remember, the diplomatic consular immunity has been mentioned today. Finally, we have special property categories which, in principle, are not liable to enforcement, do not fall under enforcement rules. This is not just the advantage of official representations. That also refers to assets or property of the central bank or other financial institutions. That's the property owned by cultural legacy institutions, or the assets belonging to institutions and properties representing cultural and historical interest. This is also an important part of international relations. Let's remember all kinds of art exhibitions having to travel from one end of the world to another. And if you have a writ to be enforced, you may want to think whether or not you want to go to take your exhibition to a different state. Remember the Sedov tall ship or the famous guest exhibitions. These are classical examples of immunity, which is one of the underlying principles of international relations. Now, let me proceed with some information based on the Russian practices. I am representing the executive power of the Russian Federation, and there are some people here who may be better equipped to discuss the application of state immunity norms in this country. But with your permission, I would like to say that there is work going on with regard to draft federal law on immunity of foreign states. It's good news that this law will and must be based upon the standards as per the Convention of 2004. The articles of Russian experts give a lot of attention to it. This law eventually will integrate the foreign sovereign immunity into the Russian federal legislation and thus enhance the protection of Russian-based legal entities. Ekaterina has already mentioned this aspect. There is yet another aspect related to international liabilities. Let's think about a situation when the immunity of the Russian Federation is infringed upon. And in this case, we have to take response measures if a foreign state refuses to cooperate in resolving the issue. So this is a kind of a rudiment. We can use this term rudiment since we are colleagues, all of us. This is our favorite norm of the Russian Civil Procedure Code, which states civil immunity. If you ask me what is the meaning, the essence of this norm, at the current stage of legal development, I don't think I'm the person to give an explanation. We do not think it's in the best national interest to maintain this norm. It is not needed to efficiently protect the rights of Russian citizens. I believe this is an issue that invites some legal resolution. We need to further improve and modernize the Russian laws to get them harmonized with the international legislation, which will enhance the potential of general jurisdiction courts of this country. So to wind up, and I have to apologize for taking such a long time, I would like to mention the previous panel. Back then, we had almost as many audience, as many as speakers, as panelists back last year. But what we see today proves that we are going the right way. We're definitely doing so, and it's important to understand it. As we draft contracts, as we prepare transactions, please let us take into consideration the actual situation of the international legal context. When we prepare an international transaction, let's please take the existence of state immunity into consideration. There is a standard governmental resolution on negotiating investment agreements, and that basically provides for a waiver of judicial immunity. I believe that I can conclude by saying that immunity is not an obstacle for business. It's an existing factor It's a reality that has to be taken into consideration at the level of practical work, and it's a norm that has a great regulatory significance for securing adequate international relations. Thank you.
Thank you. After your report, I have goosebumps, because we understand that our panel is just as important as the nuclear laws panel, because any mistake in the concept of the immunity can lead to a nuclear war. It was a very structured description of the position that you hold, and we thank you for that. As for your conclusion, when you say that immunity, state immunity, is a factor which it's like a stone in the middle of the road, you just have to keep in mind that it is there. When you evaluate various investment possibilities, the possibilities of creating relations with this or that subject with the state, or the subject that is backed by the state, we have to understand that any evaluation of that kind is connected to the evaluation of risks by investors, which is expressed in money. We don't just speak about Russia. It's higher interest rates, higher prices for services provided by a subject like that. So all our legal constructions are translated into specific losses or gains for national economies. And I think that the colleagues who were talking here before pointed that out very nicely. We'll probably travel further east, going from our country to our large eastern neighbor, the People's Republic of China, and I present to you Mr. Xi Xiamen, the judge of the High Court of China, who will probably share with us the experience of China in the immunity.
Thank you for inviting me, even though I don't have a personal story about state immunity, but I have a personal story about that I love this wonderful city made by great peoples. I sent several pictures of the St. Isaac Cathedral to my wife and my daughter with an English comment. That's strange, not in Chinese. The comment is, "Oh my God, cannot be more beautiful." So I am not a Christian. Okay. My topic. Thank you. My topic is an introduction to China's policy of state immunity that consists of two parts. The first is about current policy. The second is, in the second part, I will talk about what probably will happen in the future in China. The current policy of China is absolute immunity. There is no comprehensive statute regulating the matter of state immunity in the People's Republic of China, but it has been widely acknowledged that China's policy is absolute immunity. Why? Because the rules of policy on state immunity fall within foreign affairs of the state, and the central people's government exercises the function and the power to conduct the foreign affairs according to China's constitution. So, the central government has the power to determine the rules or policy of China on state immunity. China's position as regards state immunity has been declared in the former public statements. The Ministry of Foreign Affairs made it clear in the past public statements that China adopts the policy of absolute immunity. For example, at the end of the hearing conducted in the first instance case in Hong Kong Special Administrative Region, the case name is FG Hemisphere and the Democratic Republic of the Congo. In the letter, the Office of the Commissioner of the Ministry of Foreign Affairs in the Hong Kong Special Administrative Region, having been duly authorized, set out the position adopted on state immunity by the central government as follows. The consistent and principled position of China is that a state and its property shall in foreign courts enjoy absolute immunity, including absolute immunity from jurisdiction and from execution, and has never applied the so-called principle or theory of restrictive immunity. The courts in China have no jurisdiction over, nor in practice have they even entertained any case in which a foreign state or government is sued as a defendant, or any crime involving the property of any foreign state or government, irrespective of the nature or purpose of the relevant act of the foreign state or government, and also irrespective of the nature, purpose, or use of the relevant property of the foreign state or government. At the same time, China has never accepted any foreign courts having jurisdiction over cases in which the state or government of China is sued as a defendant, or over cases involving the property of the state or government of China. This principled position held by the government of China is unequivocal and consistent. And even in other more cases in U.S. courts, the foreign ministry made the same declaration. The courts of mainland China adopted the same policy made by the Chinese government. Some cases have been brought before lower courts, and none of them was accepted by the courts. The court issued a notification to lower courts in 2007 indicating that all cases involving foreign states should not be accepted by lower courts unless they get approval from May Court. Actually, the court has never given such approval since then. While insisting on absolute immunity, China favors resolving disputes involving foreign states by diplomatic means or in specialized international tribunals or through arbitration. The United Nations Convention on Jurisdictional Immunities of States and Their Property was signed by China in 2005. However, until now, China has not yet ratified the convention, and the convention itself has not yet entered into force. Therefore, the convention has no binding force on China. As mentioned above, China does not have a comprehensive statute on state immunity. The only law is a law on judicial immunity from compulsory measures concerning the assets of foreign central bankers, which has a very limited sphere of application, and the text is very, very short. The courts have not accepted any case involving foreign states. So we can draw the conclusion that restrictive immunity has not taken foot in China. Many bilateral investment agreements between China and other countries provide that foreign investors and the contracting country may submit disputes to arbitration, but arbitral jurisdiction and judicial jurisdiction are quite different. Submission to arbitration does not mean any change of China's position of absolute immunity. In conclusion, China's policy is absolute immunity and has never recognized commercial exceptions until now. As to specific issues of state immunity, some common views have been achieved among Chinese academics. First, state immunity includes immunity from jurisdiction and immunity from execution. Secondly, a state may waive immunity. Waiver of jurisdictional immunity does not mean waiver of immunity from execution, and the waiver must be made explicitly. Thirdly, state enterprises which conduct commercial transactions independently do not enjoy state immunity because they are legal persons independent from the state and their property, and their property is separated from other state property. A few people have different views about whether state enterprises enjoy immunity. The legal status of sovereign funds has not been legally defined as far as state immunity issues are concerned. Secondly, I will talk about what will happen in China in the future. Because more and more countries have adopted the doctrine of restrictive immunity in the past decades. These statutes and some international treaties, such as the European Convention on State Immunity and the United Nations Convention, recognize the doctrine of restrictive immunity. Most parts of them provide exceptions to immunities, thus limit or amend the doctrine of absolute immunity. As China emerges into the global economy so quickly that many people realize it is not necessarily good for China for protecting China's commercial interests by insisting on absolute immunity. China is considering adopting a restrictive approach to state immunity. The government started a program to draft a comprehensive statute on state immunity several years ago. After the draft becomes a legislature, restrictive immunity will be the new doctrine. Then China's courts will play a very important role in developing the new doctrine when cases appear before the courts. As a Chinese judge with little experience, actually no personal experience of dealing with immunity cases, I hope to learn much from you, my learned friends. Thank you very much. Thank you for your attention.
Спасибо большое, господин Сиксиян.
Thank you very much, Mr. Sixi-Yang. It's getting clear that we could have just one piece of law between Russia and China on immunity. because in fact problems and issues and challenges are very similar between the two nations. The way as far as I understand from your presentation, we're very close in terms of these considerations. And thank you very much, of course, personally, on my own behalf, for saying these wonderful words about St. Isaac's Cathedral. I hope next year you will be visiting St. Petersburg, bringing your family with you, and I hope they will like it as much as you have. We're getting back now to Russia at this time for the remaining two presentations this evening, and I'm happy to give the floor Ms. Yachevskaya, Director for the Legal Department of the Ministry of Finance of the Russian Federation, because I must say that the immunity issue and the need for having this piece of law was the matter of immunity of central banks and sovereign wealth funds overall, because it is exactly the global economic development that makes deploy a lot of national wealth outside of the national borders. So, will you please, Ms. Yachevskaya, share your ideas about the state immunity here, sovereign immunity? Thank you, Mikhail. I welcome this audience. Quite a few presentations have been made before me, so first of all I have two things as good news. First, I'm going to be brief, really brief. Secondly, my presentation will be as close to practical life as practical can be, so we can relax a little bit. But I'm in an awkward situation. A colleague from the judiciary and a counterpart from the executive branch were speaking before me, not absolutely sharing the same ideas. I represent the Ministry of Finance, that is the executive branch, and I'm not going to talk on behalf of the Ministry of Finance because it is very indirectly related to the policy of the Ministry of Finance. Let me speak as a lawyer, a specialist, and hopefully we could start a discussion because I'd love to hear what the audience have to say. In January, during the Retreat Forum in London, I was making a presentation on sovereign immunity, saying that the state hates when international arbitration makes any decisions against them, nor like to execute those decisions. But then I read somewhere in the media that Yachevskaya said that the Russian state was not liking it, it did not like it, and was not going to implement any decisions made against it. So I'll have to be cautious. Well, my presentation is ready now, and many people before me have said that there are two types of immunity: absolute immunity and restrictive function immunity, functional immunity. The practice goes towards restrictive immunity. This may be the only system where investment arbitration, international arbitration, can possibly survive. And this is what exactly relates to investment international arbitration, which is the source of most questions and doubts. If the practice goes towards making things stricter, we will kill the future for that court, for that arbitration, and it is not going to die, it is not willing to die, so the practice will be to simplify things, facilitate things. I personally am in favor of restrictive immunity, functional immunity, rather than absolute immunity, because it is just better, more precise logically, because when the state acts as the legally existent subject, it can have immunity over public property, but when the state acts in civil relations, being more and more integrated in the business environment, then perhaps the possibility and potential liability of the state appears to be quite logical and eligible. Another thing is very much important, the equality of judicial immunity and the immunity from enforcement, immunity of the state from enforcement. Strangely as it may seem, I'm in favor of the judiciary in this argument, because I think if we break the linkage between the two immunities, then judicial decisions would lose any legal sense. Very often, because the Ministry of Finance is in between economics and law, I keep facing situations where we are on the interface and we try to use very sophisticated and complicated language, trying to describe simple things, but putting all those bells and whistles aside, we would see quite simple constructions. And I'm sure no one here is possible, can say that there can be a judicial award without its execution. No. So if investment arbitration is to survive, and that we all believe is what the society and business badly needs, because any state is a priori stronger than any business. So these two institutions should not merge. Although I quite agree with all facts given before me by my colleagues, the judicial practice splits into halves. I cannot say who wins more at this time, judicial immunity combined with immunity from enforcement, or the separation thereof. There is no answer to this question so far, but maybe the answer can be found in the fact that we do know quite a few of decisions of investment arbitration tribunals not in favor of states. I am not, of course, a big expert, but I have never heard of such a decision that states had executed on their own will and accord. So that matter will be very relevant very soon. Will those immunities be separated or not? That's a real big question mark. Now let me elaborate on another aspect. I call that public law legal entities, but this notion is put in brackets, so let me explain what do I mean by these legal entities. We all know here that legal entities created by the sovereigns can simultaneously exercise private legal functions and sovereign functions. Hence, an interesting question. Those legal entities, may they enjoy sovereign immunity as they establish legal relations internationally? That is a matter that deserves thorough attention. Two practical reasons why. Let's begin with characteristics. The status of a legal entity is one, of course. The state will not be liable on the obligations of those legal entities and vice versa. Such legal entities will enjoy their own separate property, and that's what they are liable with. In my view, it would be fair to have a concept whereby such legal entities will be held liable for their obligations when they act independently. And, of course, in my view, they will definitely enjoy sovereign immunity where they act on behalf of a public body while exercising their public function. I'm not going into details about legislation. My more competent colleagues explained before me that today, indeed, in the Russian Federation, there is a bill being considered that would somehow or rather open the door and streamline some legal understanding of the state immunity matter. And most of you will know, of course, and international colleagues, let me remind you, our dear international colleagues, that currently the State Duma is considering making amendments to the civil code of the Russian Federation, in which amendments the civil code would know again that public law legal entity does exist, which is not the case today. Public-private company is not in existence today according to the current legal civil code, so it will be legalized again now. So division of its functions into public functions versus private functions will be very important. A separate bill has been submitted by the government to the State Duma on public-private legal entities, so this is really relevant. Central bank, that's a special entity. However, a central bank can also exercise state functions, and it is also a participant to civil transactions. Many of you will know a mega regulator is being created in Russia, a single body to exercise supervisory and law-making functions vis-à-vis the whole financial market here, including banking institutions, banking, insurance, and other financial instruments. So the matter of sovereignty of the Bank of Russia or the Central Bank of the Russian Federation is very relevant again. I wouldn't say we have experienced any serious difficulties there. I think it is more or less clear with the central bank. We understand the legal relationships where it enjoys sovereign immunity and where else it is a participant to civil transactions. But the federal law that we discussed before should add clarity to these relations. Why I'm mentioning the central bank now? This is because the central bank is getting more and more authority. Therefore, if authority grows of such an entity like the central bank, then the matter of immunity becomes very topical. One more example where indeed the Ministry of Finance is really concerned over immunity, that's the matter of sovereign funds. Similarly, as with the creation of a mega regulator, a decision is being pondered about creating a financial agency to place sovereign funds on behalf of the state in international markets. Because as things stand today, a decision has been made that we are ready to go away from the totally conservative policy towards sovereign funds to a more risky one, but while making that more risky policy better protected and better detailed. So we're talking about immunity for that future agency, because sovereign funds, who are, of course, part of the federal budget and belong to fall under public property, and, in my view, should enjoy immunity irrespective of the prevailing concept of immunity, absolute versus functional immunity. Anyway, those should be able to expect protection because they are public property. Oh, my picture stopped working. Well, anyway, let me continue. Also raised today was the matter of issuing sovereign bonds. Again, another important, one slide back, please. Again, a very important issue, getting back to sovereign funds. Again, this is to corroborate what I had said before. As regards issuing bonds, let me say a couple of words about that, because that is really relevant at this time. The Russian Federation in international markets in the issues international bonds every year. Hence, the matter of immunity becomes very important, because the Russian Federation issues only in foreign jurisdictions using English or American law. The very fact of using a foreign law raises the matter of jurisdiction. And once a year or several times a year, I have to face a question: what do I do with immunity? Because being a state body, we have to deal with authority. Does the Ministry of Finance have an authority to waiver immunity? Of course not. So when I sign the respective paper, I have no right to waiver immunity. Now look, I'm pretty sure that everybody here is a professional and pretty well understand who I mean. Who would be interested to buy an issuance with the legal opinion, with a legal foundation from the Russian jurisdiction? How can we possibly offer national legal protection while trying to sell international bonds globally. That is contrary to any economic rules and to common sense and logic and rules of the game that have existed there for years and decades, and Russia is a young participant. So waiver of immunity in such relationships is extremely important. And if the state, in the as represented by an duly unauthorized body, waivers immunity, that waiver will be null and void. Every time we enter international markets, we must be able to demonstrate honest and clear position. We try to go round the immunity matter. We do not waiver it, but we do not try to shop for this jurisdiction. This is a very relevant and difficult matter. If trying to make an issuance, which depends on the market condition, if we were to launch the bureaucratic procedure of waiver of immunity, and the Ministry of Foreign Affairs would never agree to that, so we will never have any issuances made internationally. That's a really important thing, and unfortunately we don't have any regulations for such things. And to conclude, because I promised to be brief, but as you start talking, you forget about time. I'm afraid it made you boring. It was boring. The UN Convention is my final point, mentioned before, which is about legal entities in the first place who are related to the state. That convention now clearly regulates which legal entities are related to the state through their functionality and are eligible to enjoy immunity, which is totally in line with what I said before. Thank you for your time. Thanks a lot. I hope you will have many questions so we can start discussion. Thank you.
Thank you very much. Then I think we can ask the audience to share their views or ask questions. Please go ahead.
There's something that's very important that took place in this panel today, and I'm sure those that were developing the panel didn't see this coming. I didn't, but it is going to be quite remarkable. We've been talking about the United Nations Convention that I pointed out during my remarks that the United States has signed. We don't sign many of these. And the remarkable part was from our colleague from the People's Republic of China, that China has already signed that convention, which is a restricted model. And he makes a prognosis that China will go towards a restricted model. Now, what does that tell us? That China and the United States will be adopting this restricted model. That's a very large amount of international transactions when these two economies come together. So if you want to make a good guess what's going to happen, it looks like it's moving in that direction. Now let me take another point of what difference does it make. I'll give you one example. In our restricted model, the definition, the idea of these statutes is to keep the governments out, give them immunity. And then there's exceptions. And there was an exception that came in this Jewish Papers case. But in the model we have in the United States, we talk about commercial activity, commercial activity. But in the UN model, it talks about commercial transaction. Now, what's the difference? In the District of Columbia case, not in my circuit, in the District of Columbia circuit, they focused upon the commercial activity. What was their commercial activity? Some books were brought over to be covered and sent back to Russia. Now, that's activity, but transaction is much narrower. You have to get a narrower line on transaction. Those books never left Russia. They were here. Now, if you read then the case that I referred to yesterday, you probably weren't here, from my circuit, interpreting the same statute, it's much more restrictive, allowing greater immunity. And as I indicated yesterday, because I wrote it, I think it's right. That there is, even in the United States, a great difference between the two views. And I don't know whether the Russian Federation has asked for certiorari to the Supreme Court. The District of Columbia Court of Appeals is not the last word. But as I announced yesterday, just last week, the Supreme Court of the United States restricted the Alien Tort Claims Act so that it no longer applies to anything that happens outside the United States. Prior to that time, people from foreign countries were coming to the United States and suing corporations for things that happened outside the United States. As of 7 days ago, that will never occur again in the United States. What's that tell you? There's a majority on the Supreme Court that are moving towards what we've all been talking about, of having an immunity that works so that countries aren't being hauled into court unless the more restrictive exceptions apply. So in giving consideration, as the Russian Federation is, of what they want to do in the future, it seems to me that we can make a pretty fair assessment as to where, as of now, the future is going. And under the UN's definition, which uses commercial transaction, I think that's restricted enough that all the countries can live within it. Interestingly enough, both the People's Republic of China and the United States of America have concluded that and have joined in. I think that might be helpful.
Да, спасибо большое. Пожалуйста.
I was paying attention to the speeches, and I see that consensus is being formed here, that the immunity is going to be here and is going to be restricted. So we have this barrel of honey, and so this big barrel of ointment, and I want to drop one small fly into it. So what is this fly? Mr. Dronov's report prompted me to think about that. This is something that international law represents. What I thought about after his speech, I think the problem of immunity leads us away from a more important issue. In recent times, we saw immunity a kind of a solution to the problem. The gates are closed, problem solved. Now, it's a temporary respite. Now, if you are protected by the immunity, the problem is not solved. It's just delayed for a certain time. The sovereignty and jus cogens is a very important rule in international law, but it's being edged out by a different rule which pertains to the protection of human rights. So the decision of the International Court, some people say it's a decision from the last century, but anyway, it's here. It's horrible that we're being fined for $50,000 daily. It's awful that our property abroad is being arrested and they attempt to sell it. Our tall ships, our jets are being arrested. It's horrible, right? And then there is the Noga affair and many other cases. But let's look beyond that. Why did it happen? Why all these problems occurred? Maybe because our state was neglecting its duties regarding the defense of human rights, its debts, and so on. And then we're scrambling to find some kind of compromise. This must be the center of our attention. The Ziedelmeier affair, when you're in debt, you should probably pay them off. And the problem of immunity might help us at a certain stage, but it won't solve the problem. The further it goes, the more severe it will become. There are many partisan kind of guerrilla attacks on the problem of immunity, from the Pinochet case, the human rights activists, and so on. And I think they will go on. And the International Court of Justice will probably make more exceptions to the general rules, as many national courts have done, especially those that are under the jurisdiction of the European Court for Human Rights. So I'm kind of arguing with Alexei that perhaps the problem of immunity draws our attention from what we could do to prevent situations like that, when we are faced with certain problems that were completely avoidable. We have one of the best specialists, and probably the best specialist on immunity in international law, Mr. Kolotkin, the Russian ambassador to the Kingdom of Netherlands, and we'll probably ask him to say a few words. Thank you. I'm not the best specialist, and I'm actually not a specialist at all. I used to be a specialist in private international law before I became an ambassador, and I have some recollections. I have a personal story which is connected to both immunity and this city. I was born in this city, but I left it in '68, so I'm kind of nostalgic. And I participated in the development of the convention of 2004. I was the head of the Russian delegation at the last stage when there were talks about this convention, and I was the special reviewer of the committee for the problem of immunity of state officials from foreign jurisdictions. Before Mr. Dronov, my colleague, will answer the question, I'll probably help him a bit, because I wanted to add a little bit of structure to our discussion. We're talking about completely different things. Not all the time, sorry, but often. The fact that immunity is limited or restricted according to general international law, but this is the immunity that is connected to the activity of the state, which is involved in civil relationships. So when we think about the Schneerson Library, human rights, this is one thing, and the decision of the International Court of Justice, Germany versus Italy, or Italy versus Germany, or the arrest warrant, or France versus Djibouti. This is one kind of immunity, and we can apply to that this wide-ranging doctrinal discussion and arguing between national courts whether the immunity of the state can be restricted when it exercises its sovereignty, at the same time violating human rights. But the other thing is the commerce, and thank you for the last speech, the last paper, because there is the Noga and Zedelmar, and our concern about that stems from the fact that we did not fulfill our obligations pertaining or pursuant to arbitration decisions, which did not violate anything. There were two decisions. In Stockholm arbitration, there was a position voiced by the Ministry of the Finance. There was the position of the President's administration regarding the Zedelmar case. But when we come to execution, there is the issue of immunity. It's a different immunity. All that stems from the state immunity, but it's a problem of diplomatic immunity, a special case. when we speak about restrictions. Diplomatic immunity, again, this is a special case. I wouldn't actually include it in the general discussion. As regards the Sedov ship, tall ship, the minority opinion in the Tribunal for the Maritime Law, Argentine versus Ghana, the decision appealed by the French court. Both judges refer to the confirmation of the immunity of a warship, which is not right. This is an error. But again, this is a special case. The Tribunal of the Law of Sea was following from the Convention on the Maritime Law. So, I'm sorry for monopolizing the discussion for the time being, but I think that we have to say something about different types of immunity. We speak here about special or restricted or complete immunity. Why do we need a law on immunity? I'm provoking on purpose. I was participating in the development of the law that was buried at some point. As far as I know, I don't know, maybe recently the practice have changed. The laws on immunity are common in common law states. Canada, US, Singapore, Pakistan, and so on. Maybe this practice was also developed in civil law countries. I don't know. This is very important. This is crucially important to understand why we need this law, because I have an impression that somebody remembered that law, not because we need to have some clarity in the legal system of the Russian Federation. There are two exclusive norms, exclusive rules. One is functional, the other is about absolute immunity. Because we need to respond, because the immunity of our state was breached or violated abroad. So we need to take some measures as a response, so that these decisions would be taken on the basis of restricted immunity of foreign states and so on. If this is the main goal of passing this law, I don't think we need this law at all. Just 1 second. Maybe somebody will answer. The laws of foreign states, which I remembered and the audience remembered, appeared after a long court practice pertaining to the immunity, at least in some states. In Russia, the court practice regarding the immunity of foreign states in the area that is of interest, where the state, being kind of a private entity here, there were a few cases, and they were all about diplomatic immunity, not the general immunity. What are the chances? I haven't heard any reference to the court decisions of Russia or in China, because there was a policy statement in China. Is there any practice, any court practice at all regarding that issue in China? What about Russia? Does it stem from court practice? And finally, what will be the relationship of this law to the convention? It's not been ratified yet. There are some other documents which also need to be taken into account. but saying that the law will be based on the principles of the convention, but at the same time it will probably develop and go further and so on. As we see here, because we see here the administrative bodies that participate in the development of this law. What will be the added value of this law? A transaction is commercial if it is a commercial transaction, but the convention actually, if I remember correctly, specifies the criterion of the goal. What will our courts do? Will they have any guidelines?
Shall we take into account both? And another practical thing is the role of the Ministry of Foreign Affairs. It was mentioned that that would be a very limited role, but for the first time ever. No, it's not the first time ever. There is some norms in the military-industrial complex that must request the opinion from the foreign ministry about immunity issues. Secondly, what is meant there is that would courts be obliged to request the foreign ministry, and what would be the amount of that correspondence, or would courts be obliged to do so, and the opinion of the ministry cannot be mandatory for the courts because of division of powers, but ignoring their opinion would also be not correct. American practice, as far as I know it, I'm not a good expert in that, of course, is far from simple, and the problem is that not on all cases the State Department offers immunity to the Minister of Department of Justice. Sometimes they do, sometimes they don't, and hence discretion, hence politicization. Sometimes the government would refer to the State Department asking to come to court, offering immunity, and the State Department could say, no, I rather wouldn't. And in that case, the State Department have to do without it. What is Russia going to have there? Well, thank you. You're asking very hard questions that could take a long time to discuss. Why don't we give Ekaterina a couple of minutes to try to answer some of them at least, and then Igor will have the floor. Thank you. Indeed, those are hard questions, and I can hardly provide good answers right now. As for judicial practice, Roman Anatolievich is very correct there, saying that immunity matters are the most irrelevant and hard questions in judicial practice. That would be very wrong. On the other hand, such things surface, not very frequently, but still we've heard about several cases. They never reached the presidium of the higher commercial court. It was done below. There was a case with the Central Bank of the Czech Republic, and some succession issues were involved. And as a result, transaction and activity was purely commercial, but the bank, who had become private, referred to the fact that at the time of concluding the contract, that had been a government function. Another thing related to the Act of State doctrine, we try to include that in the review of public procedure waiver, but it was excluded because the story was not so pure. But it was an interesting thing when the court of Tajikistan, or maybe Turkmenistan, I'm not really sure, they recognized invalid a normative act of the Russian Federation and unlawful the actions by the Russian Federation, and the plaintiff went to court for enforcement. So these things, such things do exist, and the purpose of the law, what would be the bonus from that, what would make it different from the convention? Of course, when such cases emerge, somehow or other courts, when they can, we try to explain the courts that the convention is there and that the ideology of the convention should be followed. But what's the point of having the law in place? That's in order to prescribe the procedure. Procedural codes could be amended for that. That might be an alternative pathway, but that is because of some internal interaction complexities between the arbitration and procedural civil procedures and arbitration procedures, some different procedures and different principles. So at this point in time, it was so decided that enacting a law would be a more correct way to go, a more correct approach to this problem. These things that relate to the role of the foreign ministry, well, I wouldn't perhaps reply to that, because those are the things that must be thought out well. But I don't have an opinion so far about that, whether the court must request the expert opinion in all cases, but to what extent it would be mandatory in every particular case, I'm not so sure, because as far as I remember, there were several cases where the Foreign Ministry of the Russian Federation issued opinions that courts rejected. It was not; those were not about immunity, but some transactions in which both the state and some private firms participated, and the opinion was given by the foreign ministry that that was a fully international commercial transaction, while the courts decided it was a mixed agreement. It was an international treaty when it came to the intergovernmental relations, and when it was an international commercial transaction also. So the foreign ministry may not necessarily be always right, and courts must have discretion. Thank you very much. Igor faces a very challenging thing. Much has been said before him, and everybody is getting prepared for the banquet, for the reception in the evening, but he still has the honor of being the last and final speaker of the whole business program of the St. Petersburg Legal Forum of 2013, so I'm rushing to give the floor to him. Thanks a lot, Mikhail. I just now realize how honored I am indeed. Awful. I'll try to be really brief, especially as my presentation is really practical, because I'm a practitioner myself. I work for an international law firm as a private consultant. Initially, my topic was to talk about immunity vis-à-vis cases of international commercial arbitration. There seems nothing to discuss there, what kind of immunity you can have there. There is no state component, arbitration, commercial court or tribunal. Still, there may be some questions arising there because of whatever preliminary measures requested by any party when referring to the commercial court, and the matter of execution also raise the matter of immunity. That can be really relevant. In this connection, given the fact that we kept talking today and comparing today the doctrines of absolute immunity versus the doctrine of functional restricted immunity, I'd like to give you two practical examples, specific examples to legal systems. One of Hong Kong, which is one example of absolute immunity, an extreme version of absolute immunity, and the English law system, which is an example of relative immunity. And by the way, a special act was enacted on sovereign immunity, and let me share a couple of thoughts, and I hope you would see why it had to be done there this way. Again, my reservation is why I'm taking the English law. This is no a commercial of English law and its usage, but there are several reasons for that. First of all, Hong Kong and England are similar legal systems belonging to the common law system, and while we have common law in both systems, it may be interesting to see how different they are in addressing things. Secondly, it's everybody's knowledge that there's been quite a lot of agreements made by parties following English law and shopping for English courts or English commercial courts like LCIA as the forum. So this is a very practical, not only academic issue. Every time, well, you can, one in every, let's say, 10 contracts, you will see references to English law, English courts, English arbitration, and matters relating to sovereign immunity also fall under the application, under the scope of application of this English law. I'm skipping something I won't elaborate long. If you look at this slide dedicated to Hong Kong, it can be easily explained, entitled like bad news, because a foreign state in Hong Kong will enjoy absolute immunity. I'm giving you here an example of one of the precedents, and that actual precedents which was analyzed in detail before, and that is a recent case of 2011, and the answer there is really clear-cut and exhaustive. No exceptions for commercial activity. The immunity is absolute immunity, and even more interesting, which China is no foreign state for Hong Kong. They part of the same whole. They also enjoy immunity in Hong Kong courts, but that's not a sovereign immunity, but that's so-called royal immunity, which is a legacy of Hong Kong being under the British influence, and hence that crown immunity from that time, which was given to China, that cannot be brought to Hong Kong courts. The good news down there that Hong Kong too does not enjoy immunity in its courts. As you look at this picture, apart from all those bad news enlisted there, there's one more that I did not put on the slide. There's nothing you can do about it in your contract. Whatever you write in your contract, a Hong Kong court will never use that rule. Even a waiver of immunity by a state will never mean that automatically the case would go to court. All the same, that immunity will be there. It's a totally different story when you look at England. Totally different, well, I'm maybe exaggerating. It's not totally different, because the point of origin for English law and English courts, that the state does enjoy some immunity. While there are several cases or exceptions that are provided by the Sovereign Immunity Act, where the state does not enjoy this immunity. The first case of such type was when the contract contains a provision or a clause whereby a foreign state agrees to transfer a dispute to an English court. So the state doesn't say, I refuse, I waiver my immunity. No, a foreign state could just say, we agree that our dispute will be considered by an English state court, which will automatically give the English court the right to consider that. So that's a waiver of judicial immunity there. And if we only had this kind of wording, would never mean a waiver of immunity as such, a waiver of immunity from execution. The second exemption is what refers to a commercial transaction. where we have a commercial transaction. And what is a commercial transaction? That is defined by the act I referred to. I won't go into detail right now. There, no immunity exists as well. But one thing to mention here in this connection, a foreign state that enters into a contract under English law can make a provision in the contract that in that case immunity will apply, which is quite a unique feature, whereby a simple waving of hand will turn the immunity into an absolute immunity. So the Foreign Immunity, the State Immunity Act says that if the parties have agreed, then sorry guys, immunity will apply. So it works not only one way, but it works both ways. This act, I mean. Thus, approaching the matter of arbitration, the same English Immunity Act says that where judicial proceeding that a party initiates against a foreign state in an English court falls under the arbitration procedure or is related to arbitration, while there was a written consent in place, then the foreign state will not enjoy immunity over such judicial proceeding. What does it mean in practice? If you have an arbitration proceeding going on with a foreign state, let's say at LCIA in London, and you want to have to secure some relief or injunction from an English court for whatever you wish, then if you ask for that injunction, the immunity of a foreign state will never be a hindrance to that, despite the fact that direct waiver of immunity may not be found in the contract, because such a request can be considered by an English court as a procedure relating to arbitration. And that's what you need to bear in mind. And parties are often forgetful about this risk when signing the contract, because they say we're all safe because we have an arbitration clause. We've never waived our immunity. It's not always the case, like I tried to show. And again, like it happens with a commercial deal, the very arbitration clause itself could stipulate what are the cases of judicial proceeding that relate to arbitration procedure, make the immunity applicable. So, like lawyers often say, enforcement or any disputes over arbitration start not when you go to court, but when you draft a contract. And in my view, that's a great advantage of that act, which provides flexibility to both parties in establishing terms and conditions, in specifying conditions where the immunity applies and where it does not. Because, well, there are many reasons for that. First of all, if we're talking about business, if a business party is in talks with a state, at least legally, they have an opportunity, they have a possibility to regulate cases where the immunity will not apply. And a similar possibility is what the state can have. It's like what the Ministry of Finance explained us about Eurobonds. The prospectuses are publicly available for Eurobonds issued by the Russian Federation, and it will have a separate clause on sovereign immunity there. And in fact, that clause is not going around the immunity issue. That provision very elegantly turns relative immunity of a foreign state, in this case the Russian Federation relative to the UK or English courts, into the absolute immunity, because it says what? It says that the Russian Federation does not waiver immunity, the Russian Federation does not agree to the jurisdiction of foreign courts, and that any jurisdiction is meant there, which is quite detailed in the prospectuses. including the jurisdiction of courts for proceedings relating to arbitration. And finally, that disputes will be resolved in compliance with effectively and amicable agreement procedures, which will be decided by the issue trustee. So from the perspective of that act, that's an absolute protection against any lawsuits in English courts. One other thing I'd like to mention briefly about sovereign immunity and arbitration. Immunity relating to recognition and enforcement of arbitration decisions made by foreign tribunals, by foreign arbitrations. I referred to a recent foreign precedent, a recent foreign case. That is a case, it was a dispute between a Swedish company and the Republic of Lithuania. By the way, it was considered by a commercial court in Denmark. And later on, having won the arbitration, the company requested enforcement from an English court, and that recognition and permission for enforcement were granted. Why I mention this? Because all those exemptions I mentioned before were very thoroughly detailed in that case, including when it came to the tests or criteria of what a private act was, because the contract there was very, very difficult. It was a contract on joint activity of sorts. It was really important there to define whether the Republic of Lithuania acted as a private person or a businessman, or the actions and activity of the Republic of Lithuania had to be considered as sovereign acts. And also it is very interesting to read the arbitration clause as interpreted by the commercial court, where from where you can make a good conclusion as to how the wording should be done and how you should go and define that clause if you, as you represent the state, want to retain your immunity against enforcement, or B, if you are the other side of the bar, if you wish the arbitration decision to be enforced and recognized and enforced.
In the end, I gave a list of certain problems that you have to keep in mind, or you have to stick to when you talk to the state about a contract, about a deal, about a business transaction, at least in such countries. Or if it's regulated by the British law and you are going to argue that there, avoiding these problems will help you avoid problems with the immunity of the state. What should the state do? Do everything the opposite way, as opposed to what's described here. And that would be all, I think. Thank you. Any other comments? No audio. Thank you. I would like to thank all speakers for a very interesting exchange of opinions. There are lots of questions, but I'll just limit myself to one small remark and one question. I think we mix up two entangled but distinct issues: the separation of jurisdictions and immunity, because I once happened to write a report on the Schneerson Library, and I think it's very obvious that here we have the case of the American court going outside the boundaries of its jurisdiction. And the saddest thing is the consequence that we had, because right now the cultural exchange between Russia and the United States is basically stopped. Both countries are afraid to export, to take out of the country their cultural values, and people are left without the opportunity to enjoy them. Apart from through an international treaty, I don't see a way to solve the problem of jurisdiction. Let's imagine the claims against the Schneerson Library in other countries, and would have 4, 5, 6 mutually exclusive decisions. What shall we do? I think we have to separate this question. I think the question of this separation of jurisdictions, when we have rather active trans-border, transnational relations, is of secondary importance. As for my question is for Mr. Dronov. You said that the project of the Committee on International Law is the codification of the rules of international law. I'm troubled by this phrasing. Is it the existing rule of international law, or just a suggestion for the formation of the norm of the rule? Because if we think that anything that comes from the Committee on International Law, which I respect, but saying that it's the rule of common law, okay, I misunderstood you then. Let's be a little bit more interactive. I think I misunderstood. Usually they claim that it's the interpreter's fault, but we both spoke Russian, so it's probably not. We were working within a working team and a special committee, which was a very difficult task, and Roman Anatolyevich was one of the witnesses to this process. The document that we prepared was the result of a long discussion, and we can't say that this is the material that is codifying common international law. Would be wrong and incorrect. There is an important issue. It's what's called travaux préparatoires, which is very important preparation work, which is actually very important in this context. This is just being in work, but our ministry hasn't seen this document. It hasn't been submitted for approval. There is a founded opinion about what are the basic elements of this problem, apart from the articles with comments and the report of the special committee and the report given by Professor Hafner, who was the head of the committee. All of that are parts of the context, and it's very important to take into account because the convention says that the convention cannot be applied to criminal cases. It was one of the points which was discussed very heatedly. It's not simple with this text, because otherwise it would have been universal long ago. But what I wanted to say, and I'm very thankful to my American colleague who said a very important thing. Basically, as a practicing lawyer, he confirmed my opinion. It's not my opinion, it's an opinion shared by lots of specialists in international law, that this convention, together with preparation work, based on general norms, general rules of international law. This is the compromise and the consensus around which the practice of the states in all its components will be structured in their court decisions, in their law practice, and so on. Other questions were raised by our respected colleagues, and I can't ignore them. There was the question about the Zedelmeier case. I think here we have to separate legal issues from factual issues. What's being discussed doesn't invalidate the necessity of the state to adhere to its obligations. What was done practically in the Zedelmeier case, which was my personal experience? It all started with the Ministry of the Foreign Affairs raising the question of concluding the treaty with the claimant. The Ministry of Foreign Affairs, let me stress that. If the Ministry of Foreign Affairs would be the main agent, this would have solved long ago. The problems of that kind always require a wide participation of different institutes which can have different views. The government is not just the Ministry of Foreign Affairs. The Ministry of Foreign Affairs has a wide prerogative in issues concerning the immunity, including those that are related to the presentation of official documents regarding the interpretation of the rules of international law, which we can't forget about. So I'm fully in favor of those who say that if you made an agreement with the investor, make everything to satisfy the lawful requirements of the investor. If you violated the contract, find a way to come to the court and efficiently represent your legal position. No question about that. All those proceedings are the result of a very complicated collision of circumstances. So immunity can be a cure-all from the reacting to such situations, and this is something that's being very actively discussed, because creating an efficient system of that, an efficient system in Russia is of paramount importance. That would allow us, that would give us opportunity to participate in these issues. The other question is about human rights, and here I can't say anything. We have everything about that written in the Constitution. The rights and freedoms are obligatory, mandatory for all. And the question that was reviewed by the court, and I think it's the force and not the weakness of that decision. The court that was reviewing a very delicate question connected to blatant violations of human rights in wartime conditions. There were cases of murder, cases of forcible removal of Italian citizens for forced labor, but neither for the immunity, neither for the violation of international human rights. There was no dispute between Germany and Italy. They were quite in consensus about the immunity, and except just one point: the application of the rules on immunity regarding these specific issues. And the court made a decision which is very important, saying that the rule of immunity is a procedural rule. The rule of international humanitarian law is a material rule. These are different things. These are different regulations. So, referring to the type of violation doesn't absolve us of fulfilling the obligations related to immunity. And as an international lawyer, I think this is a principal question. As regards the federal law, how it came to be, how it was taken from storage, it is my understanding that, from what I know, it's not directly related to the Schneerson library. The issue was raised before because the existing laws do not protect the protection of the legal rights of Russian citizens and legal persons. When this case appeared, it gave an impetus to all of us, and it became another factor to stimulate the development of this law. Again, because of a very simple reason. The rules of civil code limit the passing of the laws. The court will be bound by that law. And so how does it relate to the principle of reciprocality? If other countries would be ready to give us full immunity, it could probably be okay, but many countries with whom we have relations, they stand on the positions of functional immunity. So, once again, I don't see any reasons not to repeal this rule. Do we need a federal law? Well, there is the Ministry of Foreign Affairs that voiced its official position. It says it's necessary in agreement with the Convention. Our position is to take into account all the rules of the Convention. But we have to take them in their context, understanding the spirit of the Convention. I'm not sure I answered all questions. I might have missed something. Remind me if I forgot something. Well, it's probably not necessary to answer all questions. We'll take it as homework for the next year, and we'll come here with a finally written, a complete law, and we'll discuss the text and the results of today's discussion. So I would like to thank all speakers. I think we had a very fruitful and intense discussion. We, representatives of ministries and institutions working on the issues of immunity, we will bring home a lot. As colleagues pointed out, it's obvious that there is a mounting interest to this problem due to various factors, to certain specific cases and the general international situation. We have to respond to these challenges. So, the final words of today's session could be that it's best not to have any disputes at all, but if we have them, we should have the rules that would stimulate the parties to making a peaceful agreement. So thank you very much, and at 7:30 we are expecting everyone at the Manege Square for the final gala dinner. Thank you.